Hey everybody, Wendy Sellers here, the HR lady. Just an important reminder here today about free speech in private workplaces. Just recently, Southwest lost a major case because they were attempting to limit free speech when an employee was discussing their pro-life opinion regarding abortion. Now, regardless of what your beliefs are on this topic of abortion, which of course is a very heated topic, there are a lot of legalities surrounding this topic and similar topics. And because Southwest did not do the right thing, they lost a case which cost them $5.1 million due to free speech. And so want to just again remind everybody who is an employer or acting as an employer to remember that employees on all sides of this topic and similar topics or heated topics have rights which are protected under the National Labor Relations Act, Title VII of the Civil Rights Act of 1964, the Federal Workplace and Anti-Discrimination Law, which specifically prohibits religious discrimination. So in this case, the employee got a lawyer and claimed that her religion required her to talk about the fact that pro-life is the way you should go. Then the union complained to the employer about her pro-life post on Facebook, and their union, so that's even more interesting that we have the union involved, actually violated Title VII on behalf of the employer. So the union was the one that violated Title VII, and they were trying to get her fired over her religious views, specifically in this case regarding abortion. So be super, super, super careful. Either way of the aisle or in the middle of the aisle, you need to make sure that you are applying your rules, your policies, your practices consistently. Whether you, the employer, are pro or against a law or a topic does not matter. In this case, people were allowed to talk about pro-choice, but not allowed in theory to talk about pro-life, which is why she won $5.1 million. Do remember that Title VII of the Discrimination Act is specific to religious discrimination as well. We learned a lot about religious discrimination in this most recent COVID era, and it is here again in this conversation with abortion, pro-choice, pro-life, etc. Be careful how you act, how you react, and if you have a union, such as in this case, even if you don't want to have a reunion, remember that they are also representing you as the employer, as are your managers, with or without a union. They are representing you as an employer. So you need to take the time to go and speak to your supervisors and managers and let them know how they should be acting and interacting when the topic of abortion comes up in the workplace, so everybody knows what the laws are, because there are a lot of laws involved in this abortion conversations in the workplace is specifically what I mean. So again, religious discrimination is one thing that you want to be considering, and then also National Labor Relations Act. Many employers don't realize that the National Labor Relations Act does in fact protect employees who actually don't even have a union, and that's when you start getting into specifics about compensation and benefits and how we treat people in the workplace. So get yourself an HR consultant, get yourself an employment attorney, or just follow one of us online, because we're always giving out information that may help you stay out of court, stay out of the news. Of course, all the information that we give is generic, so make sure you talk to a consultant or an attorney specifically regarding the case in your organization. Stay tuned for more information soon. Take care.